6:30 p.m. Um, Welcome to the May 5, 2026 Easton Zoning Board of Appeals meeting. My name is John Curran. I am the Vice Chair, but for tonight's meeting I will be serving as Chair because Ryan Cook, who's the duly appointed Chair, is unavailable. There are 5 members present tonight, so we do have a quorum to undertake the business that's being presented to us this evening. You all probably know, but this meeting is being recorded and it's broadcast on Easton Cable Access. Let me introduce everybody. To my far left is Ron Hanberger. To my immediate left is Gene Rummel. To my immediate right is Jeremy Kay, and next to Mr. Kay is Mariam Ghali. Gene and Mariam are alternate members, but for the purposes of tonight's proceeding, they will be acting as full voting members for the matters that are being presented. Now, the first item on the agenda is a continued public hearing of an administrative appeal. The petitioner is appealing the zoning enforcement officer's cease and desist order for property located at 254 Washington Street. The members that I introduced and myself will be voting on this matter. Now, I think we read this matter into the record last time.
We did. I read it. I don't want to interrupt. Jeremy Kay, for the record, I read it into the record on April 7th, but I could do it again if you like.
I don't know if it's necessary, but maybe for the purposes of people at home that are watching for the first time, why don't you read it into the record?
Sure. The Board of Appeals will hold a public hearing on Tuesday, April 7, 2026 at 6:30 p.m. That was where we started, and we, at the applicant's request, we continued it to today. Easton Town Hall, Colleen Corona Boardroom, 136 Elm Street, Easton, Mass. Administrative appeal filed by Jeffrey Hansen as representative for Darlene and Dodgel Borgeson, trustees, owners, relative to a property located at 254 Washington Street, Easton, Mass. Assessor's map 13U, lot 15, pursuant to Mass General Laws, Chapter 40A, Sections 8 and 15, appealing the zoning enforcement officer's cease and desist notice on the property dated February 3rd, 2026. And I'll, as I did last time on April 7th, I'll read the public or the comments. Affordable Housing Trust, not applicable. Board of Health recommends. Buildings not recommended. DPW not applicable. Environmental Planner not applicable. Fire recommends. Historical Commission not applicable. Planning and Zoning Board makes no comments. Police not applicable. Water Division not applicable.
Okay, and as I indicated before, Ron Hanberger, Gene Rummel, Mariam Ghali, Jeremy Kay, and myself will be the members that are going to listen to your presentation and then take a vote. Mr. Hansen, you're the spokesperson for the applicant?
Yes, I volunteered to help out the Borgesons. I've known them for a long time. I moved here 1980. I moved to Easton, and I've known them ever since. I've been working with Don and his family, and we've become friends. So, as many of you know, and Darlene has said it's okay to talk about it, but Don suffered a stroke last November, and he's been hospitalized ever since. So he would certainly be here, and he's not been able to do much of anything to address this issue. So I said I can do it for you. As you'll see, I'll discuss what my background is, but I think I'm kind of qualified to do this kind of a thing. I've pretty much been involved with the water industry for 2/3 of my career, the last 40 years, basically. So I've had a lot of involvement with town water and those kinds of things. I am a registered engineer in Massachusetts. My family has lived here since 1980. I serve as an elected member on the steering committee for the stormwater department here in Easton right now. I've been on the management team for the YMCA. My wife has served on the finance committee here in Easton. My children all graduated from Oliver Ames High School, and so we're pretty committed to Easton. Easton is our town. And I'm looking forward to presenting the case for the Borgersons. I think at the end you should agree, I hope, with what I found in looking at this. In my working career, I'm a mechanical engineer. I developed electric generating plants, and so we have a lot of dealings with water. But I also developed the Aquaria water treatment plant. I don't know if you're familiar with that. That's the reverse osmosis plant down in Taunton. I worked on that for about 13 years, but I got it permitted. So I went through the whole permitting process of working with the Taunton River watershed and getting all the permits coming through the towns, including Easton. I worked closely with Wayne Southworth and got a connection. We actually have a connection here in Easton to that pipeline if we want to use it. And Wayne was instrumental in helping me to get that from DEP. So in that situation, I was involved a lot with the Concom and et cetera, and various groups here in Easton. So I have a pretty good connection to Easton and have been looking at water issues here for a long time. And this is basically a water issue that we're talking about here. So the whole presentation will lay out exactly what it is that's the problem and what we think is the solution. Also here tonight is Darlene, Don's brother, son Brandon, and son Colby.
Okay.
And Brandon actually works at the station. He's a graduate of Southeastern Regional, as is Don, Southeastern Regional Voc Tech. Brandon, I understand, graduated tops in this class. He's a very good mechanic. I recommend him to everybody. So they're here in support of this, and would like to move forward with it. So with that, I will.
Before we get to that, first, thank you for reviewing your qualifications and interest in this particular petition. I think it might be appropriate if somebody on the board would make a motion to reopen the public hearing. We'll take a vote on that, and then we'll proceed with the substance of your
I'll
presentation.
make that motion to reopen the hearing.
I'll second.
Okay, and by hand vote, everyone in favor? Okay, so we have all the preliminaries out of the way, Mr. Hanson, so why don't you begin your presentation first?
Thank you very much, appreciate that. So Ken, because my computer was not up to current standards, Ken has it on his computer, I'll have to direct him to flip the slides. So obviously, we're May 5th here, we'll go to the next slide. And you can skip. There we go. And as you see, the family, the Borgeson family has lived here all their life, and the children still live here. So they're, back up one, whoop, getting away from me here. So just as a background here, that the Borgesons purchased 254 State Street, Washington Street in January of 2025. They rehabbed it a little bit and then started business there, and that was January 25. And in February of this year, they got an order from the town to cease and desist because of a violation of the Aquifer Protection Zone limitations. And the reason that we're here is because the Mass General Law gives us the opportunity to appeal that finding. So we're here. And the basis of the appeal is basically going to be that we found that there was conflicting information, which really was the cause this whole thing, in the coding of the assessor's coding of this property. It was coded as auto repair. We'll get into that. But we believe that if this variance is allowed, it will not be detrimental to the public good or the intent of the APOD, which is almost verbatim out of the Mass General Law, that you can get a variance if it's not detrimental to the public good, which we believe that that's the situation here. And then the last one, obviously, is another criteria for a variance is financial hardship. The Borgesons have invested their whole life into this business. They've mortgaged their house because the seller wanted a cash deal, and in order to do that, they were required to take a mortgage on their house, so they are fully invested in it. That's their only employment, and if they lose it, that's a big problem. Especially now that it's not an automobile, allowed as an automobile repair place, that would be really make this property a lot less valuable. So that's the background of where we stand right now, and I'm going to talk to those three items. Next slide. Borgesons was incorporated in 1989, and they were originally located at Sundell's, which you're all familiar with down at the end of Lincoln Street and in that area. They had some difficulties with the owner there, and they ended up having to move out, and they moved to a location in 20 Central Street, which is the old Morse Automobile Factory. And they were that's the only place they could find, and that's why they ended up there. So they were tenants at will down there. In the meantime, the DEP found out about it in the town, and the town Concom dug into the property, and there's tremendous pollution problems down there. And the DEP got in, started doing test wells, and they found out the atmosphere down there was kind of toxic, and so the Borgesons got an eviction order after the DEP got into this a little bit. So they were basically evicted from that site. And also, the Easton Fire Department posted the big red X on the building, which is not a good sign when your house has a red X on it. So in that situation, they went to 254 Washington Street, and Don had been talking to them over the years, trying to get a sale, but the fellow wouldn't sell except with a cash deal, and Don didn't have the cash deal. So it went on and on and on. But now they're being pushed out. They had to do something, so they looked into Washington Street, and they purchased the property, which is about 1/3 of an acre. It's a fairly small lot. It's 65 feet by 225 feet. And started operation there. And eventually that operation will be turned over to Brandon. He will take ownership once Don retires. And so that will be the family business for the foreseeable future, that we don't see any change in that if they can get this variance. So the next slide. So initially, back, and I think about, it's kind of hard to follow it, but in 1959, Jenny Oil, I don't know if you're longtime residents, you remember Jenny Oil, there was a gas station there, and it was Jenny Oil. And that started in approximately 1959. And then and it changed hands. I think the original owner was somebody named Spillane or Thrasher. It was Spillane, Thrasher, and McKinney, maybe a different order. But it kept getting sold, and finally the last owner were, in 2009, the property was sold to Mr. McKinney, I think his name, and he converted from doing auto repair to masonry, concrete work. And he changed the building a little bit, but when he did that, he told the town, hey, I'm not doing auto repair here anymore, I'm doing concrete work. And he did that business up until, up until now. I mean, that was when he sold it to Don. He was still there, but he wasn't running an auto repair business. And that's kind of the rub here, is that the town ordinance talks about a 2-year window. Once a business stops, if it doesn't restart again in 2 years, then it's abandoned, and you don't get grandfathered anyway. So they would not be grandfathered, and that drove the cease and desist order, that you're doing auto repair here, but that operation stopped a long time ago, and it's way more than 2 years, and you can't restart it again. Okay, so we can move on to the next one there. They do all their repair work in the building, inside the building. The building has a concrete slab There's no drains, there's no catch basins outside. The buried storage tank that was there, gasoline tank, was removed, and that was confirmed by the fire department. And there is a domestic heating oil tank outside, inside an enclosure. But that is going to be removed. They're trying to get natural gas put into the property. And the gas company is saying tomorrow, tomorrow, tomorrow. So as soon as they get their gas line, that oil tank, that heating oil tank will be gone. It's an above grade, just sitting in a plastic enclosure. All of the oil that they have on site is collected and held in a double wall tank within a storage container that's in the backyard. You'll see that in a picture further on. All of that is picked up by Murphy's Oil Service periodically, and all the other fluids like radiator fluid and that kind of thing are stored in hazardous waste drums, and that's also removed from the site. Used tires, whenever they do tires for somebody, the person that brings the tires takes the old tires away. So they rarely have any tires on site. Once in a while, they'll end up with a few tires, but pretty much the tires come and go at the same time. In all of their 37 years of operation, they've never had any kind of a hazardous waste spill either at their site, it's at Sundell's, 20 Central Street, or at the new operation here for the year that they were operating. They had no waste discharge. There is a boat stored on site, but that's Don's boat, and it's just there for the winter. They don't do any boat work in that property. They don't do any vehicle work outside the property. This is the current conditions inside. They made an office there, an office and waiting area. You go to the next one. It has a bathroom for the customers. And then this is the shop area. They have 2 lift stations. Where are you? There we go. Oh, it won't show on that screen. They have 2 lifts. One will be there and another one beside it. And that pretty much is the whole floor space inside the garage. You go next one. And that's the backyard. Their own vehicles are back there, and there's 1 or 2 vehicles that are waiting to be worked on. But they just park them there. Half of the yard is paved, and about, 2/3 of it and 1/3 of it is unpaved. Before they bought the property, they did a title search, obviously. They checked out the property card in the assessor's book, and the assessor's book is still showing, to this day, auto repair and service. That's what its use is. It's listed in the assessor's card. So he went ahead with that. The prior owner had indicated, even though the prior owner had indicated that he was not going to do auto repair, the code was not changed. I don't know why. It would have saved everybody a lot of trouble if they changed the code from auto repair to whatever he was going to do there. But they didn't. Don confirmed with the fire chief that the storage tank was removed and there were no leakage noted when they pulled it out, so there was no contamination there. And the property deed, when they passed papers, it had no restrictions noted on it. So he had no reason to believe that this was going to be a problem. So the reasons that we're here tonight is, number 1, the assessor's records. Number 2, we'll dig into the Aquifer Protection Overlay District map, and then I'll describe to you what makes 254 a unique location, and it really is. So we'll go to the next. And this is the property card. And I don't know if you can see it, but it's indicated as code 331, which is auto repair, and the next sheet, current use, mixed use, auto sales and service. Still on the sheet today. If you look it up today, it's still there. The site is recorded, the Registry of Deeds, and that is accurate to what his lot looks like, 65 feet by 225 feet deep. This is the Aquifer Protection Zone, and you can see that according to the zone, this is 254 here. He's just clipping the edge of it. And so he is indeed in the Aquifer Protection Zone. He didn't realize that. He never bothered to look at it, didn't think about it. It was the blue is commercial zone. Commercial zone allows auto repair. And so that slipped through the crack. It really did. He didn't see that. He could have asked some questions if he saw that, but he didn't see it. And, you know, I'm pretty familiar with the maps here in Easton, and it's kind of difficult to find this one. It doesn't jump right out at you. And the next one. The overlay map was, actually, the overlay district was described way back, even though it wasn't passed by bylaw until 2017. I found a map that went way back to 2009 that showed the district on it, but it never was approved by the town. And that map was based on what they call the water table map. Now, if somebody has a water table map, I'm all ears, because I couldn't find it. There isn't any. The only thing I did find was that the whole thing appears to be based on a water level that was identified by USGS. The water table was set at elevation 127. And this happens to be down at Five Corners. This is Greenwood Village here. There's a lot there, and this still exists. There's a monitoring well, USGS monitoring well here, and it identified the water table as 127. You go on to the next one, Ken? And they measured the water table, and that's where it was. In August of 2017, the water table was identified as elevation 127. And you go to the next one. This station happens to be at elevation 150, so they're higher than the water table, granted. When they designed the aquifer protection zone way back then, they weren't mindful of all of the things that were underground. And I'll talk about that a little bit more, but this clearly, elevation, anything above 127 is in the aquifer protection zone. It's massive, this aquifer protection zone. It spreads all over the whole town. There's a few areas that are a little lower, and they escape it. You go to the next one. So this is actually the aquifer that we're trying to protect. It's the Queeset Brook aquifer. And here is their station here, and the aquifer protection zone is here. The Langwater Farm is in this area here, where they do the farm sales now, and they have crops in here. And this is all identified by Mass GIS. So this is the official aquifer protection aquifer zone, and there's a medium yield and a high yield. So they are 3/4 of a mile away from the actual aquifer. That's the distance between 254 and the yield, and the aquifer is about 3/4 of a mile. Go to the next one. Something that was not thought about, and it becomes obvious when you know about it. There is a bedrock line that runs down this area. These represent bedrock. This is the entrance to sheep's pasture, and you know that there's a big rocks there. Well, that's an outcropping. The red spots are outcroppings, and the identified bedrock here. And it creates a wall, and it comes right to the surface. This is near the surface here. And anything on this side of the wall can't get through there because there's a fall here. And the Langwater Pond is here. Nothing goes this way. All of the water flow coming from Borderland is coming this way until it gets here. And then it makes a turn and it all heads south, which clearly indicates that there's bedrock here and it's not going through there. So this is the wall between the station and real aquifer. I accept that the zone goes out here. On paper, yeah, they're in the zone, but in reality, they're not really, they can't really put anything over there. You go to the next one. This is the Zone 2 wellhead protection zone, which is very, very similar to, and I don't know whether this was available at the time that the APOD was set up, but this is actually the zone that the state DEP identifies as the no-build zone. Don't go in here. This whole area here is protected. And the reason that line is there is because of that bedrock that runs right through here. It turns everything, and it all goes this way. And so that is actually, if it were me, I would go back and review this zone that's currently in here. I don't know what the purpose of it was. Maybe there was some other reason, but nothing over here is a hazard to this Zone 2 wellhead protection. So that's kind of where we are. He's over here in the paper zone, but not in the real zone. Go to the next one. So before I wanted to jump to any conclusions, I went around and took some water samples. Obviously, I developed the Aquaria water plant, so I know how to do water samples. I took water samples at, this is Shovel Shop Pond. I took a water sample at the exit of Langwater Pond. I took another one down here at the exit of Morse Pond. And at those places, I measured the total dissolved solids, which are kind of like a fingerprint for water. And the total dissolved solids, well, just for reference, the Easton tap water has a total dissolved solids of 30 parts per million of stuff. Seawater is 35,000 parts per million salt, but other things get in there too. But anyway, Easton is 30. Shovel Shop Pond here was 190 parts per million. It continues on down here, it was still 190. It continues down here, and it was 220 down here. So these are all 220 or less. The sample that I took over here, which is right across the street from Don's place, in the brook, there's a brook that comes down here. This brook actually flows this direction. It comes down and goes this way. This was 320, which says that this water is way higher concentration of dissolved solids. And it does not go this way, otherwise we would see it in here, but it's not going that way. And the reason is that there's this rock wall here, subgrade, not too far down. So there is, the chances of anything happening here that could affect the aquifer are slim to none, as far as I'm concerned. Lastly, the family, as I said before, the family has invested everything here. They've been in this business for 40 years. They're going to pass it along through the family. Alternate locations are few and far between in Easton for auto repair businesses. And they are Easton people. They're going to stay here. They want to run their business here in Easton. And there aren't many places there to do it anymore. And then the last thing, it would be difficult at best to carry the debt service that they have right now if they get shut down. And they're going to be in immediate, dire financial straits. So I think that to allow them to be in there would be not a risk at all to anybody. And it would be very, very detrimental to them. And they got into this particular situation, and they did what they thought they should do to check out the property. They did it, and they didn't see anything that was a red flag, and apparently there was one. And so that's where they are right now.
Okay,
I'm happy to answer any questions that you might have, so.
yeah, and does anyone on the board have any questions at this point in time? Why don't we go, well, we'll go around. I'll go last, but if you want to start,
Okay.
Ron.
I know there's a bunch of other gas stations, auto repair, all along the area. Now, do any of them have a problem with contamination or in the history of it?
I did not investigate the other stations. I know there's probably 5, I think, other stations in the zone.
Yeah.
And I found it a little peculiar in the wording of the zone that they could shut down and transfer it to somebody else. Usually grandfathered things, once it shuts down, that's it. Your grandfathering goes away. But that's not the case here, and I don't know why that is. It can be sold and keep the auto designation if you do it quick. That doesn't seem to make any sense to me, but that's the way it's written. But there are others, and there was a real bad spill at the one at the corner of Washington Street and Main Street. And that site was capped, the Washington Plaza. That site is capped. Okay. And they never removed the material. It's under there. They are on the wrong side of the rock wall, by the way. So, yeah, that's the only one that I know of. I don't know if there's been, Dean Oil had some, but Dean Oil is not in the Aquifer Protection Zone. Huh? Who knew? I don't know. And they did have to do some cleanup down there. Morse Auto is very polluted, and they have to do a cleanup.
Well, that stretches back
Yeah.
100 years probably.
Sundell's is polluted, and that has to be cleaned up. They've got all kinds of chemicals going on there. So there are other polluted stations, but fortunately, it didn't seem to impact our water, our drinking water.
What is the number of particles that would indicate polluted water?
What is it?
I-
Well,
the 30
it can be
was
very
for
low
the
because hydrocarbons dissolve in there.
Yeah.
And they can be there in very low numbers, and then it's polluted. So we don't know what's in there, we just know that there's particles in there. And they don't separate. The only way once something becomes dissolved in the water, there's only two ways you get rid of it. You either boil it, distill it, or you do the reverse osmosis. Naturally, it's in there forever. The rocks won't filter it out. It just is there, and if it gets washed down into the aquifer, then it's a problem. Fortunately, most of Easton has glacial till, which is very impervious. Water doesn't like to go down through it, so it just carries along. And we don't have any problems with surface spills, per se.
Anything else, Ron?
That's it for me.
Jean?
Yes, thank you. Thank you very much for the presentation, and I think that you seem to have really taken the family's concerns. You're presenting them very well.
Thank you.
But I don't know that our job, I think, is to try to have a critical review of the information you've provided, and I hope I can ask some questions that help. First, to you, Mr. Chairman, or directly to Mr. Kay, I believe when he read the reports, he said environmental reported nothing? There was no report from environmental on this?
That's
On
what
the
it said.
comments.
There was an old one, old report.
The comment from the municipal review on environmental planner said not applicable, dated 3/13/2026. That was their response. I think that,
So I would just say, as a statement to this board, that confuses me. I mean, it seems that this is applicable, but, okay. The source of your slides, would you, I have a little bit of question. You have some very colorful slides, and you've got the town planner who's actually presenting them for you, which I don't know if they've been vetted through the town. Has the town,
These
No,
are,
no,
are
no.
they're all town slides?
They're
No.
either MassGIS, ArcGIS is the site, Permitize, that kind of site, but they're all on the Easton Maps site. You can
No.
find them in there.
Gene, we were kind of discussing this before you arrived, but Mr. Hanson had a thumb drive with these slides.
Oh, I see. I beg your
And
pardon.
he needed, and Mr. Kirkland graciously offered
I beg your
to,
pardon. Okay, I just want to understand
allow
it.
him to
Okay,
present the slides through the thumb drive that's running off of his computer. It wasn't an endorsement of anything
Okay.
by Mr. Kirkland or whatnot. He's just trying to facilitate matters.
super. Thank you. Can you say, you said that the property was sold in January, purchased in January 2025, I believe I got that right. The zoning, the current zoning against the prohibition was still in effect at the time of that purchase, correct?
There was no inquiry into the town because it was just a cash sale and a relocation of an existing business. So the town, the deed is recorded and it's recorded as auto repair, but it didn't get vetted. Let me say, it didn't get vetted by the town. There was
But-
no need to.
But it didn't get vetted by the purchaser either, is that correct?
By the purchaser?
Yeah, I mean.
Only
the-
insofar as what I showed there, title search, the normal things that people would do.
Unless you're in the business of perhaps running auto mechanic,
Right.
business where you know that hazardous materials are
And they
concerned.
considered looking at the property card, and the property card was current, and in 2025, it was recorded as mixed-use auto repair in 2025.
Well, what was the property card expected to say, other than a code? I mean, how is the property card?
There's a different code, there's a code 330, which would be a different kind of use, not auto repair.
I do understand that, but I'm just saying that it seems to me that the purchasers decided that they would look at an assessor's card. I don't know where that's a
They
standard
decided,
to look at an assessor's card and
Well,
didn't,
that's
and
kinda
didn't go
normal.
further. Okay.
When you're
did-
buying a property, that's the first thing that anybody looks at, is the
But
assessor's
they may
card.
ask, I'm just saying, they may ask other questions
Yeah.
of the health department, of the building commissioner, of the zoning enforcement officer, maybe one and the same. So
Mm-hmm.
I would have expected that. Did the sellers represent the property as a feasible business site for auto repair?
I was not there. I assume that because it was an auto repair, he bought it as an auto repair shop. He said, well, I'm gonna sell it as an auto repair shop. That's how he bought it. He bought it as auto repair.
Even though
McKinney.
you had the paperwork that you presented that showed that that use had stopped.
You can-
That's correct.
You can go back in the history of the assessor's view site visits,
Okay.
all the way back, and it always was auto repair.
Okay, on the unpaved section of this lot, what is stored on the unpaved section?
Nothing.
So is it no cars, no nothing, no personal vehicles? It's
On the
vacant?
unpaved part?
Yeah.
Nothing, no. The storage container is on the paved part.
But
and
just,
they don't-
are there vehicles? Is there machinery? Is there anything on the unpaved part?
No.
Okay. And you talked about the removal of hazardous waste drums. Is that all Clean Harbors that does the removal of their hazardous waste?
I don't know the vendor that takes those
Oh, I
away.
thought you mentioned it.
Could
I
be
thought-
Clean Harbors or
I
somebody like
thought
that.
you mentioned it, okay. So the buyers have they taken any action against the seller for misrepresentation of the property as being something that's a viable use for auto repair?
No.
Okay. And is it possible, Ms. Kirkland, go back to I have a question on the slide about, where you're talking about the ledge or the
Right, the bedrock?
bedrock, yes. Oh, I see, 254 Washington Street is just one of those squares?
Yeah, this is
Yeah.
138 here.
Okay,
And when you're at Langwater, you can stand there and look over and you can see, oh, there's a mountain. You have to go over the mountain. And that's the bedrock. There's a
But
big
we-
hill there.
okay, but the bedrock starts at some point, so there's some elevation. Is it not just that it's rock, but that it's at an elevation higher than that?
They describe it as close to the surface. The bedrock, in this area, bedrock is close to the surface. They didn't do any drillings all the way out to find out, to give a whole profile. They just said that USGS says it's close to the surface in all of these areas. If you dig down a few feet, you're gonna hit bedrock.
Okay, but it's not between those two reddish lined
There is
areas,
bedrock still in here, but it's just not really shallow. It would be deeper.
but it's something
It's all connected.
feasibly, could
Yeah.
pollutants pass
This-
through that, or?
Yeah, the whole region here, this whole region of Easton and all these towns, because the glaciers came down, I'm gonna get into this, because the glaciers came down north south, they made.
But you're trying to make your point
lines.
geologically, okay,
Yeah.
okay, I understand, all right. I think, Mr. Chairman, I think that's all I have for this moment, thank you.
Okay, Jeremy, do you have any questions?
I do. Thank you. Good evening. So first of all, this is you're requesting. I want to just make sure I'm understanding the standard that we're supposed to be applying here. You're appealing the zoning enforcement, as opposed to applying for a variance. Is that accurate?
When I read 40A, B, or whatever it is, it talked about a variance, as opposed to a special permit. That's a town thing. So I gotta be honest with you, I don't know whether we need a special permit, which would require more submissions to you folks.
Well, I'm not even sure this is either an application for a special permit or an application for a variance, as opposed to an appeal of the enforcement action by the zoning inspector. And I don't know. I don't know if the standard is the same, but that's one concern I have.
In reading through the requirements for special permit, it all looked as though it was for special permits for something to be done, not something that's there already. And so it's more like a variance. To me, it seemed more like a variance.
But you'd agree that the application doesn't say anything about requesting a variance, does it?
Requesting a what?
You're not the
I
application.
have not, and indeed, because I think it's variance, but I couldn't stake my life on it.
So I'll just say that I read it as an appeal of the decision of to enforce by the building inspector as opposed to an application for a variance. And so the next question is that this was somebody requested that the zoning enforcement officer enforce this act. Do we have any idea who or why they?
I do.
Do you want to? I mean, I assume I don't know if that
I
person's
know that
here.
this all came about because another nearby property was being resold, and the new owner wanted to put in auto repair service, and the response they got was that, no, you can't do it, you're in the wet protection zone. And the statement was made, well, how about them? I don't know why you didn't say, how about those other 5? But
Got it. So it wasn't like the competition, or maybe it was sort of the competition that, I don't know.
I don't even know what they were planning on doing there.
So then the next question is, so they got it,
Which, by the way, was right up to the day of the foreclosure was an auto repair service. So the 2-year thing didn't kick in that situation. Now, why they were turned down, I don't know.
well then, in any event, my next question is, so they didn't take out a loan on the property that they were purchasing. They took equity out of their home to buy this.
Right.
And so they wouldn't, I mean, I'm guessing that if they had sought a mortgage on the property that they were purchasing, they would have needed to have, the bank would have required some kind of zoning
The
opinion.
bank probably would have required a Title V.
Correct.
A Chapter 91, all kinds of things. If a bank is going to give a mortgage,
Right,
they're super careful.
right. And so shouldn't a purchaser be the same way? I mean, they have,
You're not if you make a judgment that you look at the paperwork says it's okay, you make a judgment, and they made that judgment, and
the bank would have hired an attorney and looked to see if this could be done there. And I would just feel like the purchaser should have probably done that too. You said, so they bought this in January of 2025, and you said they did some rehab. It was a mason
no, they cleaned up the inside. It was a concrete guy that was working in there, and it certainly wasn't presentable as an office and somebody to come in and sit and wait for their car to.
So what did they? So you said that they rehabbed it a little bit. What does that mean?
They painted the walls. The bathroom needed a doorway, those kind of things.
Was there
Nothing.
plumbing done or electrical work done or anything like that?
I don't know. I think the lighting was upgraded to the latest technology, but I don't know.
Were any permits applied for?
Because the plumbing was already there.
Just,
Oh, the permit,
I have to insist, for the record, could you go up to the microphone and, we know who you are, but just for the record, introduce yourself? Thank you.
there was a permit open for some work, and I don't know what was on that permit.
I'm sorry, ma'am, you can use that microphone over there. You don't have to, you can sit down, Mr. Hanson. It all seems very formal, but it's necessary. I apologize.
I'm down was, we just put in, there already was everything there for the bathroom. We just put the vanity on the pipe that already came out, and there was a hole for the toilet, and that's what we did. And then we just put down tile floor. And then we painted, we spray painted, and the lights that were there, we just put much brighter ones in.
Okay. Thank you. Unless there's something else you want to add. I'm not trying to cut you
No,
off.
I was just answering that question.
Thank you.
All right. I don't have any other questions right now.
Mary?
First, thank you for the great presentation. But my first question for you, all of this are based on your own research, right? Regarding the environmental issues for the water table elevation and all of this, correct?
I'm sorry, say that again?
Okay, for all this environmental research you already showed us now, This based on your research, your own research,
Yeah.
correct?
Mm-hmm.
Is there any third party certified saying or showing the same result you are showing us right now? Do you have any reports showing the same thing from a third party, something? Okay, just saying the same thing regarding the environmental issues?
I think my basis for doing the water test was to just put the stamp on it that indeed the aquifer protection zone that the state has established on that one slide there in a different location, that yes, indeed, they're right. And my numbers showed that, yep, they're right. So it's the state is the third party, if you will, that gave me the line that this is the zone that you have to stay away from. And the actual wording of the way the DEP identifies it, it's the critical scientifically delineated area of an aquifer that contributes water to a public water supply well, serving, pumping, and under severe pumping and recharge conditions. So they have scientifically delineated this, the state has. They've come up with that aquifer protection zone, the green one that I had there, not the one that Easton has developed many years earlier. This was done in 2025. This is something recent. I don't know how far back it goes, but it's pretty recent. So
That's why I was asking if there is somebody else, a third one is just saying the same thing you are saying right now.
yes,
But,
same thing.
so, but you don't have a report from a different place, because now you have the ADPO. Or I'm saying it wrong. I'm not sure.
Aquifer Protection Overlay
Yes.
District, yeah.
And you are saying something now. So what I'm saying, if there is third one, just approving what you are saying or approving what is shown in the town map.
The zone is what it is. It can't be changed. We have to live with it. Okay, so that's why I want trying to prove that, okay, we can live with it, but it's not dangerous to have this business be there. Even if we live with the law, the way it says, you can't be there, you live with it. But by leaving it there, and 40L says that if you can prove that it's not to the detriment of the public, which I think we can, then it's okay, you can give a variance. That's what the law says, 40A, B.
And for the last 2 years, there is no proof at all that it was used as a repair shop or a garage.
He was running a different kind of business. He was doing concrete work,
Oh, okay, thank you.
which had storage of materials that are hazardous. Muriatic acid, lime, all those kinds of things were stored on site. It was much more hazardous when he was there, to be honest with you, than it is now.
Okay, gotcha.
It was quite a mess when they took it over and they made him clean it up.
Okay, so it's my turn. I have some questions as well, Mr. Hanson. First of all, I'm curious, in the packet of material, one of the things that was provided was a copy of a immediate response action plan modification report for the property on Central Street, which was the property that your clients occupied
Correct.
before.
Yeah.
I'm wondering, why is that included here? What relevance does that have to what we're trying to decide tonight?
It forced them out to make a quick move. They didn't have any time to search around. They got a letter, said you're evicted. And so they couldn't say, well, okay, you know how long it takes to buy a house. You look around for a year or two and maybe you find the house that you're looking
Right.
for. They had to find something quick. And so they had been earlier discussions with the prior owner on this site. So they had already started discussions with him. And then they were able to get a deal, make a deal after they said, well, we got to get out of here. Especially when the fire department put the X on the building, which said, don't go in.
Okay. I understand. Now, I did a little bit of sleuthing myself before the meeting and accessed the Mass DEP website for all the properties that they follow throughout the Commonwealth of Massachusetts. And the property on Central Street did pop up, and there was a notice of responsibility. It's a term of art, but a notice that was provided to the owner of that property back in 2008, which was prior to when the Borgesons moved in there, saying that there was a release, a DEP, a release of hazardous material. The DEP was following it for a while, then it seemed to have kind of fallen off their radar for whatever reason, I don't know. But in the years that they were there, that the Borgesons were there, were they aware of the fact that that was a property that was being followed by the DEP for the release of hazardous material?
I don't know when they first showed up. Do you remember, Darlene? They've been poking around the site for a couple of years.
Well,
Yeah.
and it's probably not ultimately relevant, but in point of fact, the DEP was investigating that property both before and after their occupancy of that building began. There's a reference in one of the documents about how there were several auto repair places there. And I guess the point that I'm maybe trying to make is the fact that, or just to wonder if there was an awareness that they were operating in a facility that was being followed for the release of hazardous material. I mean, in other words, is it something that they're mindful of based on their prior experience with their prior landlord?
Being lifelong residents of the town, they were very familiar with Morse Auto and that property. There's no question about that. And if you ever visited it, you would walk in and go, boy, this is a dirty place.
Right.
There's a lot's going on here. And over the years, the owner has been addressing some of the issues. He removed some tanks. He's been working on it to clean it up. Not as fast as DEP would like, probably, but he has been working on it. And so they were just renting. They weren't owning. They were just renting. And they needed someplace to move quickly to move out of Sundell's with the Washington Street, the Main Street operation. And that was available, so they moved down there. All the time looking for someplace to go, and just nothing else opening up here in Easton. He did try and open up, get a site over on Union Street.
Yeah, that was mentioned in the
Yeah,
material.
in Union Street, he actually structured a deal with the owner of that place, and he began doing some renovations over there, and then, I don't remember if it was Concom stepped in. Somebody disputed it, that they didn't want him there. There was never any ruling on it that said he couldn't do there, but he backed out of that. And in my mind, it turned out to be a good decision, because that oil, if you've ever been down there on a humid day, that site is totally polluted.
Right.
It's very polluted. So it's a good thing that he didn't go there, but he did negotiate a deal there and was ready to move in there, and started looking at, well, what do I got to do to move in here? But it didn't happen because one of the residents objected to it, didn't want an auto repair shop near his neighborhood, and I think you know who it is. And then the whole thing died.
Yeah, I don't know, and
Yeah.
I guess it's probably, I don't want to get off
Don't want to get
track
into
here.
off track.
But basically, getting back to my original question, the copy of this immediate response action plan is you're letting us know on their behalf that they found out about the problems on Central Street in 2024, and not anytime from June or from 2011 when they moved in there until they received notice of this immediate response action.
Those were all, I may be wrong on this, but I believe those were all relative to subsurface pollution kind of things. The eviction notice that they got was because of toxic fumes,
Right.
the atmosphere. And I don't think that was going on at the time that you're looking at here.
All right. I don't want to get too far down that rabbit hole, but you've explained why that was provided. Now, as Jeremy was pointing out earlier, this is presented to us as an appeal of, it's an administrative appeal of a decision by the building inspector, who's the zoning enforcement officer in the town of Easton. My direct question to you is it your position that the building inspector incorrectly applied the applicable Easton zoning bylaw?
No, I don't think, the bylaws, if you read them, they are what they are. I don't disagree with that. I just see that there are some special cases where exceptions can be made, and I believe that this is one of them.
Well, and I think you kind of short-circuited some other questions I was going to ask. So this isn't a situation where the building inspector misunderstood what's required under the Aquifer Protection Overlay District, correct?
I don't remember the exact numbers. Section 201, I believe, is the Aquifer Protection Zone bylaw. That's where the specifics come out.
Right.
And indeed, it says that if a business is abandoned for more than 2 years, then it can't be restarted.
Right.
And if you look at the map, 254 is within the boundary of the zone. So it's pretty much cut and dry from that perspective. But there is the ability for you folks to review the situation, the specifics of it, and this specific location. If he was on the other side of the rock mound, okay, you got a point. But where he is not really germane.
In preparing your presentation, did you review the bylaw for the Aquifer Protection Overlay District?
Yes.
And is it your interpretation of that bylaw that an exception can be made through a variance as opposed to a special permit?
Yes, that I think Mass General Law, Chapter 40 allows a variance on that.
No. I want to be very specific with you. I'm not talking about the Mass General Law. Mass General Law does have, there's a statute that talks about variances, but what we're talking about is the APOD in the town of Easton. And I think we would agree that an auto repair, I'm trying not to
in
put
the
words in
list.
your mouth. Just,
It's in the list,
So you
yeah.
agree with me?
Yes, I do.
It's a prohibited use. And in that circumstance, is there a section of 235, Section 46, that talks about what can be done to obtain a permission to use the lot for auto repair?
I'm not familiar with that. 246 is the
Yeah, in other words,
paragraph?
the
235.
235, Section 46. I'll read it to you. It's subparagraph E, and it starts, special permit uses. Within the APODs, the following uses shall be allowed only upon receipt of a special permit from the Planning and Zoning Board. I'll get to that in a second, because that might present the other issue here. But then, any use involving toxic or hazardous materials in quantities greater than those associated with normal household use and golf courses. Now, I'm not trying to interrogate you, but just to kind of short-circuit things, you'd agree that running an auto repair facility would involve the use of toxic or hazardous materials in quantities greater than normal household use. I mean,
I don't know. They're not on site, they don't have any large quantities. They buy what they need for a particular vehicle, and they buy it and they use it. So a lot of people have 4 quarts of oil sitting in their garage, but I don't think it's to the magnitude that there's large quantities of hazardous material there.
I'm not
Or
trying
there is the waste oil, you're right, that's there.
Right. And then, so there are procedures for a special permit that are then outlined in paragraph F. Was any consideration given to applying for a special permit? At which time you could present all of the somewhat compelling reasons why an exception should be carved out for this family to use this, this lot for an auto repair business?
When I looked at the language for obtaining a special permit, it all, as I said before, it all hinged on if you're gonna do this, if you're gonna do that. It didn't really fit the situation where we got an existing thing here for a special permit. There was none of the questions and answers in there dealt with this kind of situation, so it just didn't seem to fit.
The property hadn't been used as for an auto repair since 2007.
Somewhere in that vicinity, correct?
Right.
Yeah.
And when it was acquired by this Mr. McKenney, he was using it for
Some other kind of business.
some other kind of business. So it's a different, it seems like, I'm not going to put words in your mouth, it seems like it's a different kind of use. I mean, an auto repair facility is not the same as a masonry company. Now, whether or not there should have been some inquiry or whatever into what was being done as a masonry, it's another question for another day, and I'm not sure that it's relevant to what we have to decide here this evening.
Yeah. Hindsight's a wonderful thing, but what he did was he looked at the records for that particular piece of property. He looked up and down the street, saw a lot of other gas stations operating on 138, and thought, this is commercial property, I can go.
I completely understand.
Yeah.
And you've made reference to the assessor's card. I mean, is it your position that the assessor's card qualifies as an ongoing non-conforming use?
It is. It says auto repair, current use, auto repair.
Right, that's what the card says. And the
Why is
reality is that it hadn't been used in that capacity for a number of years.
But there had been several site visits in recent history, and it continued, every site visit continued to call it auto repair.
When you say,
Recent, 2025, 2024,
when you say,
2021.
when you say site visits, could you maybe expound on that a little bit more for
I
me?
don't know, it says on the sheet, site visit. That's all I know.
Okay,
Yeah.
so because it's, to overcome the hurdle that you have to overcome here, you think the fact that the card says auto repair qualifies as ongoing use? So that you kind of get grandfathered in here. It's not a use that's been abandoned for 2 years. Over 2 years.
The paragraph about the 2-year abandonment, they were not aware of that paragraph. And a lawyer maybe would have, but they weren't, and they.
Yeah,
it's-
I'm not trying to criticize what they did. I mean, and that's, the abandonment or non-use is also defined in the zoning code. It's zoning code, excuse me. It's in 235, section 24. A non-conforming use or structure which has been abandoned or not used for a period of 2 years shall lose its protected status and be subject to all of the provisions of this zoning bylaw, provided, however, that by special permit, and we're talking about that again, the Zoning Board of Appeals may reestablish a non-conforming use or structure otherwise abandoned or not used. If there would be confusion, I could see if the confusion arises out of the fact that you have this ordinance that talks about what rights a property owner can take if they're trying to overcome the abandonment issue, compared to what's in the bylaw for aquifer protection overlay districts, because there, the permitting, the zoning board does not have any authority over that. That's by virtue of that specific provision in the Aquifer Protection Overlay District, that goes to the Planning and Zoning Board. And I'm not trying to, I'm just trying to explain to you some of the issues that I'm
Yeah.
wrestling with here, because you've made a compelling emotional case for, why the Borgerson should be allowed to operate their auto repair facility where they are. We're going to have a debate about it later amongst all of us, in front of you, of course, but I guess the point I'm trying to make is that they're not without recourse, or they had some other means of recourse. It's probably more difficult, sure, and it might require more standards to satisfy. But there is within the context of that zoning bylaw governing aquifer protection overlay districts, a method by which they could get the permit to operate their business.
I agree, but I continue to go back to the way Mass General law is written. You have the ability to cut to the chase, if you will, and say, this is not a danger to the public. It's okay.
No.
Yeah, but those standards would also be applied in the context of applying for
Correct.
a special permit. The variances, with all due respect, you're kind of comparing apples and oranges when you talk about variances and special permits. And there's a specific procedure.
Well,
It's,
is it not true that first step is to appeal the ruling? I mean, there's no,
yes, I
we
mean,
can't
and
appeal to the planning and zoning board.
right, and the standard that we have to follow, and that's why I asked some of the questions earlier about whether you think that the building inspector incorrectly applied the zoning bylaw. Your answer was no. So if the answer is no, then what are
I
we
see the
supposed to
predicament, yes.
overrule? How are we supposed to overrule the decision by the building inspector, who's the enforcement officer? I mean, we would have to find that there was some, speaking for myself and just the way I'm analyzing this, that there was some misunderstanding of the underlying facts or an incorrect application of the facts to what's required under the ordinance, the APOD ordinance. I don't see where any of that is being presented to us. That's all, and it's just my observation. We still have to deliberate on this and whatnot, but
Do we need public comment?
yeah, I'm going to get to that in a second. I guess I had questions and maybe some comments. Before I ask if there's public comments, does anyone else on the board have a question?
I have more a procedural question. Is it possible for us to amend this into allowing for the variance for this use?
No. I mean, I don't think so. I don't see
I
where
don't know, I'm
it's...
not, you guys are the
No,
lawyers.
No.
because there's a whole procedure set out in 235, section 46. We can't,
See that?
it just, and a good case can be made for why this property shouldn't be in the Aquifer Protection District, but we can't, we don't have the authority to start saying, well, that district shouldn't be the size that it is. That's way beyond any authority that we have. We have to apply, in my opinion, what we know what the size, what the district is, and then we have to rule on this based on what's been presented. There's a very good argument to be made based on what Mr. Hansen said, that there's minimal danger and it shouldn't be the size that it was, and none of us know why they decided to draw it the way that they did, but they did. And then we have to work from that to arrive at a decision.
Just think,
Well, are you going to ask questions, or are you
I'm
kind of
just gonna
commenting?
Comment.
Well, why
comment.
don't you
You-
save that for when,
Okay.
when we have our deliberations? Now, I know this Q&A went on for quite a while. Does anybody from the public have any questions that they'd like to ask or comments that they'd like to make? Okay, so perhaps at this point, it's appropriate to close the public comment section. Mr. Hanson, is there anything else? You've heard a lot of the questions that we've asked. You gave a very thorough presentation, but is there anything else that, based on the questions that were asked and what you've heard, that you want to put or give us in
I'm
support?
an engineer. Everything is, to me, everything is a 0 or a 1. It's yes or no, or it's black and it's white. And so that's the way I like to look at things. And I get frustrated by the people interpreting, no offense here, people interpreting
okay.
words.
I'm used to it.
Words to find a way that, oh dear, what if this, what if that, what if that? But the bottom line here is there is no hazard created. That, I don't think anybody here can dispute that. And so there ought to be an easy way that doesn't cost $20,000 or $25,000 to get there. And that's what we're talking about here, to do all the stuff that the special permit spells out that you need to do about groundwater studies and geological studies. There's a ton of work. And I'll be honest, we want to try and avoid that because it's expensive, very expensive. And we're talking, forget about lawyers' fees, they're nothing to do that special permit. And I think it would be a crime to make them do that, knowing that it's just going to not result in any findings. That the situation is clear, that this is not a public hazard, and that was the intent of the Aquifer Protection Law. That's the intent, to protect the public water supply. We're not doing anything that is going to impact that desire, and they want to protect the public water. And I agree with that. I'm all over that. But in this particular case, there is no hazard. And so I don't know why we would want to force them to do all of this extra legwork to come up with the same conclusion. Okay, you're good. That would be like, wow. I don't think that would be fair to the citizens of, these citizens of Easton. Pay all their bills, pay their taxes, run a good business, satisfy many, many people in Easton with their business. I just think it's not fair, and that there ought to be a way to cut to the chase here. And maybe it's not the variance. I think it is a variance. I think that the law says that you can do a variance, but whether you're the right board, whether it's planning and zoning, but planning and zoning doesn't have an appeal process. You can apply for a special permit, but you can't appeal a ruling that already kicked you out. It's just not set up that way. That it's intended to look at, I want to build my something or other here. I want to build Hilliard's Candy there. They went through the whole process, and they ended up getting what they wanted. But that's at a great expense, and I don't think it's fair. I just don't. That's my personal opinion.
Okay.
And I understand your position too. It is black and white for you. Does it meet the rules? No. Sorry, you can do that. But I don't think it's right, and I don't think anybody would challenge you. If you want to make them do special things on their site, that belt and suspenders kind of thing, they're open to that.
Whether anybody would challenge it or not can't factor into our analysis and our decision, because there's no way of knowing. All right.
I'd make a motion to close the public hearing.
All right.
A second that, please.
All right. Why don't we, by hand vote, favor? All right. Yeah, that's 5-0. All right. So, Ron, it seemed like you had some things that you wanted to get off your chest, so maybe this is a good time to do it.
look at it, the assessor's records aren't official designations of the use, it's just for assessing purposes. So they're not necessarily reliable for a case like this.
Okay.
The maps, the, you know, my experience has been with flood maps. They're not always accurate. And a mass mapping is not always accurate. I don't know exactly how they do it. I assume it involves a flyover and just taking some general guesses.
In these particular situations, it's based on drilling,
This is
actual
all work.
field work. This is not guesswork. The things that I'm looking at here with the bedrock and that, they were actually drilling. They did drillings.
They didn't do any drilling on the other side of Washington Street.
They just found out where the bedrock was, and bedrock goes on forever.
It's just,
So, I don't know.
Yeah, I think the hearing is closed.
pardon me?
Yeah, that's, you know, Jeremy's making a good point.
Yeah.
I'm trying to be a little loose about this for my own reasons, but yeah, at this point, this is, any further discussion has to be among the five of us.
Okay.
So, let me, you said something about these cards, because that's kind of one of the points of contention. And you are, just for the record, you are in the
On the Board
assessment.
of Assessors.
Right, so why don't you explain to us what,
The little I know is it's a method of classifying uses, and the valuation has nothing to do with that use. So that's probably why they're not upgraded every time there's a change of use. You could have a retail cabinet shop in the same commercial area, and there'd be different uses.
okay.
You have auto sales, you have auto repair. There's probably half a dozen of the
Thank you.
330s.
That's helpful.
Yeah. Jean, do you have anything you'd like to put out there for us?
I just think that in trying to stay straightforward, as Ms. Hanson suggested, I go right back to the building commissioner, the zoning enforcement officer's letter. And he doesn't talk about the fact that this is a threatened hazard. He talks about the fact that it's just not an allowed use. If you'd applied for any permits, you would have seen, it says, I realize there was a repair shop, but if you applied for any permits, you would have been told that it was not an allowed use. So this notion of permits is something not satisfied, a little bit like what we've talked about. I don't think that the question, it's not fair even to the applicant to suggest that there's a cut to the chase mode. I can find nothing that was brought here. Regardless of our powers, I don't think it's up to this board to try to craft a solution. What I'm hopeful for is that the applicant will tell us how we can grant them relief. You know, what are the roads that they're expecting we could travel down to get that relief? I know that the applicant has talked about some notion of a variance. We've talked a little bit about a special permit, but I think that the question isn't about whether it's a hazard. The question is about whether or not it's a prohibited use in an APOD, and is it in the APOD? Yeah. So I can't see how we could, I don't see any argument even presented here as to why we would overturn the building commissioner. And I think that's what's before us, the zoning enforcement officer.
Okay. Jeremy, do you have?
Yeah, I mean, it's pretty straightforward to me. We did an independent review of the building inspector's decision. I agree with him. I think he's right, and I don't think our job here should be to cut corners or to try to craft some way. I mean, I'm sympathetic to the applicants.
Yeah.
I mean, I wish they. I don't want to say what I wish they had done, but I wish they had known this before they bought the place. But so My motion, I don't know if it's appropriate yet, but my motion would be to affirm the building inspector.
All right, well, before we get to that, Miriam, is there anything that you want to add?
No, just what you
Okay.
said.
I mean, anything that I would say at this point would probably just echo the points that have been made thus far. And I mean, in terms of, what you said about taking shortcuts, I mean, it's ignoring the zoning ordinance, deciding that an aquifer protection overlay district isn't properly constructed or set out. I mean, if this was a situation of equity, now I'm going to sound like a lawyer, where the elements of fairness come into play, I think that you'd be hearing a lot of different things from the members of the board, but we have to follow the rules. We can't just decide we're going to be, if anybody's ever come here with a compelling case for why they should get an exception, I think it would be your clients, but we have to follow the rules. And what I was trying, and I think that if you reflect on some of the things that were said, I mean, we have to have a vote, but there are other means of pursuing this. Anyway, does anyone else have anything they want to say? All right, so
I'm just wondering why the building inspector didn't just say, instead of the cease and desist, this is what you have to do, apply for.
because he's not, the building inspector isn't an attorney.
No, but
And,
he's the
you know,
zoning
and I've been,
agent.
a lot of what I've been saying here is speaking as an attorney, and it
Yeah.
kind of borders almost into giving legal advice, which isn't necessarily appropriate either. We gave this applicant a lot of time, and at the end of it, I think Gene kind of hit the nail on the head. I mean, we have a very narrow thing that we have to focus on. I mean, I don't think the building inspector is in the habit of giving legal advice to people whose properties he inspects, nor do I think that he's has the authority to do that. It's harsh, it's terrible, but it's just.
So your interpretation is that it is not in your ability to give out variances. That's your position. You cannot give variances.
We've closed this week.
Well, I can't answer any more questions for you, sir, but I think I answered that question. You asked that question before when the meeting was open, and you did get an answer. And I'm not trying to be disrespectful, but even as we're voting on this, we have to follow certain procedures when we're assessing these cases, and I passed the point now. But that was covered before. Does someone want to make a motion?
I move to affirm the building inspector.
Any seconds?
Oh, excuse me, just would ask, is that the same as move to deny the appeal? Is that
Same thing.
the same thing?
As far as I'm concerned, it's the
Okay,
same thing.
then I would second that motion.
All right, well, why don't we be, no, let's be clear. Is the motion to affirm the cease and desist letter, or is it the motion to deny the appeal?
I'm more comfortable with denying the appeal, frankly, just because it's an appeal, it's from a procedural.
Sure, fair. The way I was interpreting it was the same thing. But
I
understand.
I'll move to deny the appeal.
I would second.
Okay. Since this is important, why don't we do a voice vote? Ron,
I'm opposed,
you're opposed to that motion?
yes.
Okay. Miriam?
I would support.
Support the motion?
Yeah.
Jeremy?
I support my motion.
I am in favor of the motion.
And I support the motion as well. So I don't do it with any joy, but the motion carries 4-1.
Thank you, Mr. Mayor.
Get out of here.
Thank you. Yeah, it makes me feel even worse.
No, I'm
Oh,
awful.
That's why this job,
We give the big bucks.
this position is difficult sometimes. Okay, well.
all right, we're 162 Pine Street.
Oh, yeah, that's mine too.
All right. On to the next matter on the agenda. This is a public hearing for a special permit for the property located at 162 Pine Street.
Would you like me to read it?
Yeah, just why don't we let things settle down here a little bit.
You off?
Oh, yep. Yeah, do stuff. I should just hit share again. It doesn't automatically, but.
Oh,
Oh,
Is that your
this
family?
my family. Yeah. We got a soon-to-be graduate from UVM on the left, which is exciting. So,
no kidding.
Very good.
yeah.
Did he like UVM?
Yes, loved it. It's a great fit.
Excellent. I have 3 sons, all of whom applied, all of whom were admitted. None of them went.
You're kidding. Well,
they'll
I'm
be
sure they
darned.
landed where they were
Where'd they
supposed
end
to.
up?
So there's-
Oh, that's
All over?
all over.
Okay.
Okay, so why don't we start over here? We're on to the next item on the agenda. This is a special permit for the property located at 162 Pine Street. Jeremy, could you read the application or the item into the record?
Sure. The Board of Appeals will hold a public hearing on Tuesday, May 5th, 2026 at 6:30 PM at Town Hall, Colleen Corona Boardroom, 136 Elm Street, Easton, Mass. On a petition of Shoveltown Classic Homes LLC, petitioner and owner, for property located at 162 Pine Street, Easton, Mass. Assessors map 43U, lot 121.
I'm not getting the slideshow to come
Oh,
up.
something with duplicate.
For a special permit pursuant to Mass General Laws, Chapter 40A, Section 9, and Easton Code Book, Sections 235-24, 235-25, 235-54, capital B, Section 2, and 235-56, capital A, for demolition of a pre-existing non-conforming single-family dwelling on a non-conforming lot and reconstruction of new single-family home on the premises. The agenda will be posted 24 hours in advance. Comments?
I can look it up on.
Affordable Housing Trust, not applicable. Board of Health recommends. Building Department recommends. DPW, no comment listed. Environmental Planner, not applicable. Fire Department, no comment listed. Historical Commission lists the comment incomplete as of April 10th, 2026. Demolition review by Historical Commission of proposed demo of structure more than 75 years old required. Planning and Zoning Board recommends. Police Department complete. Water Division recommended.
Oops. Ooh, I think I did. I duplicated it, but it's not showing up. Oh, open. Hold on. Nope, that didn't work. I do have I have a flash drive. if
And
you want.
share. It's, we press share.
I could send a copy. I could email it as an attachment.
Yeah, just send it to me.
Okay. Okay, I'll do that. I'm sorry.
No, take your time.
Ken, what's your email address again?
Okay, Kirkland.
At Easton.
Yeah. Easton.ma.us.
Okay, Suzanne, for the purposes of the minutes, would anybody like to make a motion to open the public hearing on the application for this special permit?
Motion?
Okay, Marion's made a motion to open the public
I'll
hearing.
second it.
We're on second by hand vote, 5-0. And Attorney Trevison, when we fix the technical glitches, you can get started with your presentation.
Did it come through?
I'm looking, give them that.
They're good-looking kids, though.
Oh, well, thank you. That was many years ago. That was actually, we were in Venice.
Venice, I was gonna say.
We were the last plane to get out before COVID hit in Italy, and it was crazy.
That was early.
That was a while ago.
Yeah, that was February of 2020, so.
What kind of store is that?
So our last name is Italian, and it stems from a region called Treviso. So there are a lot of shops called Trevison around, and we thought that was kind of fun, so. Took the picture in front of that.
I got it.
Huh?
HDMI.
Oh, sorry. That would be helpful. Okay.
Ken, what will we do without you?
I know, right?
Survived without me before.
I hear a song. I hear a song.
I did bring hard copies as a last resort, so if it doesn't work.
I'm seeing double.
What?
I said, I'm seeing double, and it was a joke.
Oh, okay. I'm
Sorry.
very slow on the uptake.
And I should keep my day job. I was not so funny.
Do you have a day job?
You and I can talk in the parking lot then. Do now.
It's a really short slideshow, but I did bring hard copies.
Thank you.
That's all right.
Why we get paid? What we get paid to do?
Yeah.
I like this.
All right, so, again, my name is Tanya Trevison. I'm with Marioni, Shaughnessy, and Udy. I'm representing the applicant here, Shoveltown Classic Homes, LLC, and its manager, Rick Pucciolini.
Can you speak a little louder? I'm a little.
Sure,
I'm a
I'm
little
sorry.
hot, yeah.
Yes, I will. Priscillo, who's with me tonight. So this is a special permit application to raise and rebuild a single-family home on a lot that predates the enactment of the zoning bylaw. The second page in your packet shows the locus. So you can see the property is located in the residential R1 zoning district and also within the level 2 wellhead protection district. The site is 0.22 acres, that's 9,583 square feet, which is undersized under the bylaw, which requires 40,000
Right.
square feet, acre zoning. The next page demonstrates the existing conditions on the property. So there's a single-family home that is there, comprised of 2 bedrooms, 1 bathroom, an enclosed finished porch, and a finished garage with all total measure 961 square feet. No one has resided in the existing home for at least 15 years, and the latest research indicates that it could be as long as 20 or 30 years. So the existing home no longer meets current safety or building standards. There are advanced structural deterioration that renders it unsafe and impractical to rehabilitate. There's a failing foundation element, there's water damage, rot, and mold. And so the relief that we seek here today is under section 235-24 of the zoning bylaw, which requires a special permit to reestablish the non-conforming use structure of the home on the undersized lot. And then also we're seeking relief under 235-25A3, which requires a special permit because the proposed home would exceed the volume and footprint of the original home. So the following and last page of your packet is just a condensed view of the site plan, the project plan, which is also in the application materials itself. This was more meant for a slide just for reference, but the proposed new home would not be constructed within the exact footprint of the existing home. However, the new home would be constructed within the setbacks as required under the zoning bylaw and would be, in fact, less non-conforming than the existing home. The proposed new home would be a benefit to the town, and the surrounding neighborhood would eliminate the current blighted condition of the property. It would increase the value of the property and thus taxes for the town, and would not adversely impact either the integrity of the neighborhood or the town's infrastructure. So I'd be happy to answer any questions that the board may have.
Well, why don't we start? Ron, do you have any questions?
Has there been a perk test done on the site? I drove by it today and I saw the backhoe was ready to do its thing.
Ready to go. I'm going to
And it is a mess.
I'm going to defer to my client. If you could just step up to the microphone and
And just
Advise
for the
the board.
record, state your name, please. And address.
Rick Pasolo, 15 Jenny Lynn Street, North Easton. Perk tests were all done. All engineering has been done by Frank Breiblin. Everything's been done as far as that.
Okay.
that's it.
That's all I've got.
Jean?
Just one on the project plan page. Am I looking, is that light red outline the footprint of the existing structure?
Yes.
And so when you say it's less non-conforming, is that in terms of side yard setback as well as front?
For all the setback requirements, yeah. So
Oh.
there's another, the grayish dot line, you can see the
Oh.
setbacks around the proposed home. All the 20 foot in the front, the 15.
Yep.
Yeah.
I see that,
Okay,
yes.
yeah.
Okay, thank you.
You're welcome.
Marion, do you have any questions?
Just you need a relief from the bylaws for the lot size and the frontage as well, right?
Not the frontage, no.
Because
just the
here
volume.
it's written 100 feet, so I'm not sure if this is you are referring this for the frontage
25.
or this is something else.
So the proposed home would be set back within the front yard setback requirement. So it's a 25-foot setback requirement?
I'm not talking about the setbacks, I'm talking about the frontage.
Oh, the frontage,
Yeah.
oh, okay.
100 feet?
So the lot is not changing in size, that it is just,
But I know the size, it is the same, but
Yep.
I'm just asking, now, for the existing frontage for this lot, is it 100 or 150?
according to the site plan,
Yes.
it is 100 feet.
So in this case, you are seeking a relief from the frontage as well, not only the lot size.
No.
It's an well,
It's non-conforming anyway.
right.
Yeah, I'm not arguing this one.
Yeah.
But now it's not non-conforming in terms of the lot size and the frontage as well.
Oh,
Both-
I see what you're saying. Yes, I'm sorry. I misunderstood your
it's okay.
question. Yeah, non-conforming in both respects, yes.
Okay. I don't have any more questions.
I don't have any questions either.
I don't have any questions. Well, we know, Mr. Rosillo, you're an interested party. Is the one member of the public?
One more, Mr. Kern. The Historic Districts Commission has to rule on this, is that correct? Or is it?
No.
No, because it's not.
It's not a
older.
historic,
Okay.
no, it's
All
not
right,
a
thank you.
It's not older than 75 years?
I don't believe so.
Oh, I thought it said.
Because they said. in the
They said it in the copy, I read
The
it.
comment was, that was the only thing was in the comment.
It said it was incomplete.
It said, Historic Commission said demolition review by Historic Commission of proposed demo of structure more than 75 years old is required. So I read that to make them think it's over 75 years old, but
Okay. Well, if it was built in 1940,
It's quite old.
60.
then it is
It's
older.
older than 75.
Or
You
you're right.
too, buddy.
See, I became a lawyer, so I didn't have to do the math, but yeah, okay. Then I would require, I would say that perhaps the board could condition approval on, approval from the Historic District Commission. If that's required, we'd be happy to do that.
Fair enough. Any other questions? Anyone want to make a motion?
Do we,
Make a motion to close the public hearing?
did we already give the public a chance to?
Yes, yeah, he's,
All right, then I'll make a motion to close the public hearing.
anyone
I'll
second?
second it.
All right, by hand vote, 5-0. All right, any further questions or comments that anybody on the board would like to make in connection with this?
I drove by the building and it is worse than the pictures depict. And it has no historically significant design or character left.
Yeah,
Well,
It will fall down on its own within a few years.
assuming the Historical Commission agrees, I think that the whole thing looks great.
well, yeah.
And this is why I recommend we drive by our subjects.
Yeah, no, I mean,
Great.
I looked at it and I actually am friendly with some people that live up the street on Pine Street who've lived there for well over 35 years, and they didn't think anybody had lived there in all the time that they've lived on Pine Street. They're not next door neighbors, but just, so I think it's been vacant for a very considerable period of time.
Okay.
Friendly with people.
I don't know, after what happened earlier, maybe not. We'll see. Okay, anyway. Anyone want to make a motion?
I'll make a motion to approve it as proposed, subject to the approval by the Historical Commission.
If needed.
Well, it's needed.
Yeah. Okay. Anyone want to second that
I'll
motion?
second.
Okay, seconded by Mr. Hanberger. Why don't we do a voice vote like we did last time? Jean,
I would
support the motion?
support the
to-
motion, thank you.
To approve, subject to
To
the...
approve, subject to the Historic District Commission
Okay. Marion?
requirements.
I will approve the motion.
Ron?
I'll approve.
Jeremy?
I will approve my own motion.
Sure, and I'll approve it as well. So carries by 5-0.
Thank
Good
you.
luck.
All right. Thank you.
You're welcome.
So you're all set. I have to stay here for the next one? Okay. But I'll
Thank you very much. Have a good night.
Good night,
So-
thank you.
about
That sounds good.
Okay, Thank you, yep.
Appreciate it.
Okay, the next matter on the agenda is the request for an extension of time for, this is on variance number 25-58169. It's for property located at 40 Bristol Drive. Once again, the 5 members who've been previously introduced will all be deliberating on this. Mr. Hanberger, Ms. Rummel, Ms. Gali, Mr. Kay, and myself. I get to be, well, does anyone want to make a motion to open the public hearing on this request for an extension of time?
Motion to open the public hearing.
Second.
Anyone? Second, by hand vote. 5-0. Attorney Trevison, the floor is yours.
Thank you, Mr. Chairman, members of the board. Again, Tanya Trevison with Marioni, Shaughnessy, and Udi, representing Stonebridge Homes Incorporated. With me is their general counsel, Salim Kadura. So essentially, as the chair noted, this is an administrative matter. We're seeking to extend by 6 months the time in which Stonebridge Homes may exercise their rights granted by the board in its variance decision dated June 24th, 2025. The variance had granted the rear yard variance from the rear yard setback requirements to enable the construction of a 2-story office building partially within the rear yard setback. The variance is set to expire on June 24th of this year, as Stonebridge Homes has not yet been able to commence construction on the project. Most recently, on April 6th of this year, they were able to secure an order of conditions from the Conservation Commission. The next step in the process is them working with the Planning and Zoning Board for their review and approval of the project. So, as I said, we're just requesting an extension by 6 months under Chapter 40A, Section 10, to have until December 24th, Christmas Eve, to start the construction on the project.
Okay. Anybody on the board have any questions?
No, sir.
The only question I have is the delay due to the potential for the sewerage extension that is semi-planned for that area?
I'm going to defer to.
I think the delay was,
again-
yes, Salem Kadora as introduced by Attorney Trevison.
Thank you.
On behalf of Stonebridge Homes, General Counsel for the applicant. The reason for the delay was obtaining the order of conditions. We wanted to be sure that the footprint of the building was acceptable to the Conservation Commission before proceeding with getting architecturals and presenting those to the Planning Board.
Any follow-up, Ron?
No?
Jean, any questions?
No questions, thank you.
Miriam? Jeremy?
No,
I don't have any questions. And I guess
doesn't appear there's anybody from
there's
the public here.
there's nobody from the public to question anything, so anyone want to make a motion to close the public hearing? What?
Yes.
Oh, all right, well, so we just vote on it then. Fair enough. All right. Anyone want to present a motion?
I move that the board allow the request for an extension of the variance until 24 December 26.
I'll second it.
Miriam seconds. Why Why don't we just do this by hand vote? It's pretty cut and dry. Carries 5-0. Extension is granted. Thank you.
Thank you very much.
Very much. Good luck.
Okay, on to the next item. We're now in the business portion of the meeting. Has everyone had a chance to look at the minutes from the last meeting?
I have.
Anyone have any questions? Suggested changes?
No, sir, I don't. I'd move to approve them.
Okay, anyone want a second?
Second.
Okay, by hand vote, 5-0.
Ms. Forna, I was not in attendance, so can I vote?
Yeah, we have this discussion all the time. I don't think it I was, way back when, the first time this came up, I was told you can still vote to approve.
I vote to approve the minutes as written.
But even if you didn't, it still carries. We
Okay.
have 4 votes.
It's
so.
correct in that I wasn't there. I mean, it mentions that I wasn't there, so
Yeah.
I know that much.
Okay. Yep. No, I didn't think it mattered.
Okay, it may
You
not.
know what? Next time this comes up, I'll see if I can clarify that, assuming I'm sitting in this chair then. Now,
Did you want to vote to abstain or to vote?
she abstained.
No, actually, I don't think that's,
No, I didn't abstain. I voted for it.
Oh, you
on
did.
the
I'm sorry.
No, on the suggestion that it, I just wanted to remind the chairman that I hadn't been there.
Okay,
Okay.
fair enough. I'm not the chair,
The
just the
acting
acting
chair,
chair, and the
excuse me.
acting chair does not have any updates. Does the director have any updates?
Nope, just, nope, just that town meeting's coming up on the 18th, and this was a tough meeting, but town meeting's on the 18th, and see everybody then.
and our next meeting is June 16th?
Correct.
Okay. So, anyone want to make a motion to close this meeting?
I do.
Jeremy makes a
Second.
motion to close. Ron seconds by hand vote.
Thank you.
Thank you.
Yeah.